Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Julie Grantham talks about advising clients on new copyright schemes. So, let's tear it down. How are you today, Julie?
I'm doing great, Mike. How are you?
I'm pretty good. We took a trip to Memphis. We drove a long time. I'm tired. And then I came back and it was Monday. It turns out Mondays happen, whether you just came back from a trip or not. It's the worst. But we are talking about important things today, so I'm glad I came back. We are talking about a document. It is this document. It's an agreement for marketing and brand development services as between Random Company A and Random Person B. So tell us, Julie, real quick before we dig into it, what is this document? When are we going to see it?
You are going to see this document when you have a client that comes in and wants to market and brand develop for their clients. So this is an agreement for your clients, to say that briefly.
Got it. Yeah. And it's this is sort of an exciting one because this is a document that you worked on. So we're going to go through a bit your thinking process, how you were, weighing the different interests of the client, what they actually stated that they wanted versus what you thought was better for them. So it's sort of an exciting run through your thinking process. Before we do that, tell us about you. What's your background? What brings you to this kind of client engagement?
Well, I have been a lawyer since 1999. I have primarily been in-house. I have served as the general counsel for two different companies, one intellectual property technology company and the other an international construction company. So I have most of my experience working in-house. I consider myself a business person just as much as a lawyer.
Perfect. All right. So you will understand how these people are thinking about the nature of this engagement. All right. So before we dig in too deep, I want you to give me a bit of the background. What is this document in terms of who's the client? What did they when they came to you and said, let's write this thing, what are they after? Tell us about A+ Photography.
Great question. A+ Photography has been an old client of mine. The company has been around for decades, so they are hearkening back to the time when photography companies were offering our portrait, photography that hung in our hallways and living rooms, above the fireplace. It's a mom and pop shop that has really grown and expanded, and they are now making their footprint in the digital world and working with their own clients to develop websites, working on client brand development, helping clients have a social media presence that's consistent with their company. So really getting out into broadening their services beyond just the click and develop photography that they have been doing for many, many decades.
So is it fair to say then sort of the engagement with you in terms of their thinking about their relationship with their client is rooted in this? I took some pictures. There are pictures. Someone owns pictures. Who owns these pictures? And now it's sort of morphed into this, as esoteric as the digital image was, now we're talking about brand services, and it starts to get really esoteric. So there's probably, I'm assuming, still sort of rooted in this, I took the picture, who owns this thing? I do. And now you're trying to move them into a more modern conception of ownership. Is that sort of what's going on in the background?
That's a fantastic way of stating it. And the reason why I chose this particular contract is I kind of had to drag my client kicking and screaming to some realizations. And then I also had to just lay out the facts and let them make their choices in some other areas.
Cool. All right. We'll dig into that. And I appreciate you sharing this document. The fact that it's sort of a live document and one that's been used is really useful. So let's jump down to 3.7 and 3.8. As you mentioned, they're creating assets. So there's this creative act of coming up with, images and brand logos and designs on a website. They're coming up with this thing, and there's obviously a question of ownership. So talk to me about 3.7. It says trademarks. The photo company may create or develop trademarks for the client and in these different marks. It says such marks remain the sole property of AP. What do you think of the photography company? What do you think about the way 3.7 came to be?
Well, 3.7 was one where I had to lay out the facts and tell them they're going to have clients that are going to disagree with this clause. The reason why is that when a company is hired to draw a logo, create a logo, help create synchronicity across different advertising and marketing platforms, the person that it's being drawn for and is expecting to own that particular item when the work is completed. So this was a difficult one. I did explain to this particular client that they will have clients of their own that will mark through this provision. But it goes back to the mentality of where we were, a couple of decades ago, 3 decades ago, when this company was simply a photography company. They believed there was ownership over their work product. So trademark being the first one, and which will lead us right into 3.8 is copyright. But so this was a clause I didn't agree with, because I think it will always be a clause for this company that their clients won't agree to.
Yeah, I want to ask you about work for hire, but before I do that, let's talk about 3.8 and the copyright bit. It seems to sort of mirror the idea of 3.7, but tell me about the copyright section.
Well, the copyright section, let me stop for a moment and explain on the work made for hire doctrine, what that really is. So work made for hire was created by the U.S. copyright law. And generally, whoever creates a work is considered to be its, quote, author and its automatic owner. But under the work made for hire doctrine, it's the exact opposite. So if you create something for your employer, it's work made for hire. It belongs to your employer. Also, in situations where someone hires you, as in this company, to create something for them, it could explicitly be work made for hire, depending on how the contract language reads. There are a couple of other things that go into work made for hire and the criteria that has to be met. I can run through those real quick. It's really just 3 main bullet points.
Sure.
The client specifically orders or commissions the work, so it's going to be work made for hire. If also the work commissioned is used for, the courts use a 9-prong test. I won't go into that, but most work for made for hire will meet one of those 9 prongs. And then thirdly, whether the contract with the client explicitly states this work is, quote, work made for hire. So it's very golden language to have in there if you want it to be considered work made for hire.
Can we then jump down to ownership, to 9.1? I'm going to read this because there's a relationship between what you were telling the client, what the client wanted, that I think is really interesting. 9.1 talks about work product and says explicitly all materials developed by this company for the client are subject to trademark and copyright and patent and similar protections, shall be deemed work product. Client agrees all title and interest to work product is not deemed works made for hire within the meaning of the Copyright Act. How did you feel about that? Like, do you feel like this is even effective? I mean, thinking about those different prongs that you're talking about, does saying the opposite, it sounded like you mentioned if it says explicitly this is works made for hire, then that qualifies. Does saying the opposite disqualify it?
That's a really great question. And the courts have been split on this in a few different areas. But this client particularly wanted to have ownership of what they were creating. And you'll see it throughout the document. And it's what you pointed out is exactly on point. Stating this is work product that we maintain is the opposite of work made for hire. So we've said it in one place, this is not work made for hire. And then we've explicitly said this is actually work product.
I'm going to ask you to give me a little bit of a 101 on this, just for helping with the context. So I'll give the example of this show. When I, do this show, Law Insider hires me and my company to create these episodes, and it is work for hire. And if I'm understanding correctly, that means not only does Law Insider own the ability to publish this video as it is, they also own the ability to iterate off of it, to create other product, to use it where they want, to sell it where they want. What is the relationship between once something is identified as work for hire and the continued use of that work that's made for hire?
Again, a great question. And that all goes back to what it says in your contract. Because a company could say, let's divide the 6, let's take 6 and leave the other 6 for you. And I say that, I mean, we'll allow you to own this amount, Mike, we'll allow you to own this particular part of the work that you're creating, but we want royalties on X, Y, Z. So this is when you get into discussions of, who's going to own the royalty rights? Is it an exclusive or a non-exclusive right to ownership? who's going to be able to license it. So there are lots of ways, and there are many different ways for each party to have a percentage of ownership of how this work product is going to be used in the future.
It's interesting because I'm not advising your client here as someone who creates, I am someone who creates creative product. It is if I were hiring a marketing and brand development agency that had, their contract reflected this kind of understanding of creation, which is really sort of a 30, 40-year-old conception of what creative work does. I mean, this is sort of a business red flag, not just a contract red flag. This is a conceptual understanding of creativity that might get in the way. When you were dealing with the client and you were talking to them about this, maybe this is a big picture question, but how do you make the business case for rethinking the nature of creativity and copyright and work for hire?
Great question. The client in this particular case that came to me are of an older generation. Now they do have a younger generation coming in relatively soon, and I can bet you dollars to donuts we'll be redoing this contract in about 2 or 3 years.
Right.
So it is exactly what you said, that each generation has viewed ownership over the creative process. It's much more fluid today. So this will definitely be a contract that I think we'll be revising in 2 to 3 years when the new generation takes over this company.
Yeah, such an interesting thing dealing with clients. But let's jump out of this ownership part and see what's reflected in sort of the indemnities and the liability that's taken on for the work that's done here. So let's jump down to 8 and 8.1. There's a section called Client Indemnity. Client shall indemnify, defend, hold harmless AP and everybody else. You included the word indemnity with 2 E's, which is always fun, because it's the same word just spelled differently, but it applies. Just language is great. Tell me about this section and how you were thinking about the indemnification bit with your client's client.
Right. Well, interestingly, we've just spent all this time talking about my poor old clients that are so old and from another generation. Yet, I do have to say, when it came to the indemnification and the client liability, meaning their clients, not my client, but my client's liability, they were spot on. They knew that when things went on the internet, when they were going to be working with their clients and creating social media, managing social media pages, they were very clear that they did not want to be responsible for what their clients were putting out there. Right. And if you look specifically at Section 8, which is indemnity, there's a provision that specifically calls out that my client would be indemnified for any inaccuracy of information supplied by the client, period. So opinions and different things that may be interpreted by the general public as offensive or anything of that nature, my client said, I don't want to have any responsibility for what they're putting out there. I want complete control over their social media page, or I don't want any control over it at all. Mm-hmm. So it was an interesting, from a branding perspective to see, how is this going to work? You want to have responsibility for developing their brand on social media, but you don't want to be responsible for what they post to social media. Yeah. So we had to draw a line with that.
Yeah, I'm again, this is a bit 101 and I'm trying to understand, but if I say in a contract, this is all mine, this is mine, this is mine, this is mine, it's still mine, I want it, it's mine, but you're going to do stuff with it and I'm not responsible for that, and have a nice day and we don't know each other, right? Like those two things seem to contradict, but they exist in this contract. Do you see conflict between those two? Do you think a court might see those two? It's reminding me of piercing the corporate veil kind of idea. Like if your family money is mixed up with this thing, with your company, you obviously have more control over this money than you're letting on as an individual. Is there conflict in here that court might butt heads with?
I think there is. There may be, certainly. I do think that while there may be those inconsistencies in those two areas, interestingly, there is consistency between 8.1 and 8.5, which is the client liability. So like you had mentioned earlier, how there were two provisions of the same contract, one saying it explicitly and then one sort of unsaying it, if you will, the work product versus the work for hire. Here we have, you're going to indemnify me, and not only, and then I'm going to say it another way, you're going to indemnify me and you're going to have client liability. So it's sort of a way of double saying it to make sure that you're getting the point home. But that was important to this particular client. They wanted to make certain that they were indemnified from anything that people put on the social media page that they were help branding and creating. And they wanted to make it clear, not only are we indemnified, but you're the one that's liable. If something, I'm not going to be held liable for what you choose to put on your social media page that is disruptive or that may incite, any behavior in other people.
Yeah. Big picture, as I think about this, there's a bit of a cliche here about, the olds don't understand this stuff and the youngs understand this stuff. And I mean, the reality is lawyers don't understand this stuff. There's a lot about, even when we're dealing with copyright and ownership issues, when you start thinking about this, the blockchain and NFTs and all these new forms of ownership and creativity, there are things that we don't understand. And so thinking big picture about your role as an advisor, as a counselor, to be able to advise on this particular thing really well, you almost need to really understand that client's business better than they do. And I don't know if that's a realistic expectation if you're going to nudge them. And if that's not a realistic expectation, how much is our job just to go and do what they asked you to, just go in and put it to paper and see what happens and deal with the negotiations. Big question, but what's that relationship for you as you're advising clients between feeling like I need to understand every bit of this versus my job is to the client and they're going to tell me what to do and I'm going to go do it?
Well, you bring up a point that actually has even a third layer to it. You point out, shining a light on what the client wants and is it going to work in 2022 and the era that we live in where there is such fluidity between online presence and responsibility, but the third layer behind all that is courts and the laws are still playing catch up. We're trying to codify and put into play case law that addresses these issues. So right now we have constantly been, as technology has continued to evolve, we're continually we're about 6 rows back in the law trying to find out how do we address this from a legal perspective when the case law we have is historic. It isn't looking forward. So we're slowly playing catch up all the time.
It's like an anti-Moore's law. Is it Moore's law where, the computing power is going to double and get half as expensive? And so technology has just been hockey sticking for so long. And law is just sort of, I don't know, what's the reverse of that, sort of putt-putting along and falling farther and farther behind. It's an interesting thing. And I think especially where the rubber meets the road, where you're dealing with clients and who are individuals making choices and, you've got to advise them on how to move forward in this fast and also slow context. So I appreciate you bringing this document to us. It really gives us an idea of these wrestling matches that you're having both with yourself and with the clients. If people want to learn more about your practice and what you do, Julie, what's the best way to reach out to you?
Either through LinkedIn or jgranthamlaw.com. That's a website that doesn't focus on anything that we've talked about today. It actually focuses on relational contracts. So it's a different animal altogether, a different show altogether. But that's the best way to reach out to what I'm doing.
Well, that's fun. Perfect. I will make sure that is included over at the website at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email us. We are at community@lawinsider.com. Julie, thank you. We will see you guys next time.
Thank you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.